Hello guys, my name is Amaan, medical intern at LEXIS and Company. I am faculty of law at the university pursuing 3 years law. So the topic of my today's video is the case of Carlill versus Carbolic Smoke Ball Company. That was a landmark decision that was given at the time of epidemic, and this is also relevant in the corona's time that our country is going through. So the country of the England that witnessed one of the deadliest virus back in attacks back in 1918 and 1919 called the Spanish flu or influenza. Influenza disease that is caused by a virus that gets transmitted from one person to another uh, through airborne respiratory secretion. So if a new strain of influenza virus occurs against the population with no immunity or an outbreak involved, so the cause of the extreme mortality of the pandemic came to be known as the influenza type A subtype H1N1. So which resulted in millions of deaths. So the pandemic occurred in three ways as it's expected of the COVID-19 virus also. So the facts of that case, now if you talk about here in this case of Carlill versus Smokeball Factory of 1892 case, the Carbolic Smokeball Company offered by the means of advertisement to pay £1,000 to anyone who contracts the increasing epidemic influenza, cold, or any disease caused by catching a cold. So as per the printed direction, they even included common flu to show their seriousness and their sincerity in the contract. The company deposited 1000 pound into the alliance bag. So Miss Carlill used the ball in the same manner as was prescribed in the contract, but still contacted the virus. So she sued the defendant and demanded a refund from him. So the contention of the plaintiff was that it was claimed by the company that the advertisement was just a casual advertisement, as they had no intention and they had no time and to think and create it, and there were no intention to enter into a legal obligation also. So they described it as a mere puffing advertisement, as it was not made to any one person in particular, and there was no communication regarding the acceptance by the plaintiff, and also no consideration was present in the proposed contract. So because of this, there is no need for them to pay any reward to the plaintiff. Then the defendant's contention was that the strongest argument as per the defendant was that one generally gets an offer and is accepted by him, those same should be communicated as well, but in this case it was not communicated by the plaintiff. The court held that it was not a speculative offer, but a definitive one. So it was mentioned in the advertisement that while consuming the smoke ball, if anyone contracts influenza or even common flu, he is entitled to receive a reward. So the advertisement caused the customers to see and act upon him. The money deposited in the bank showed the seriousness of the behavior of the company about the offer, so it cannot be considered as a mere puffing incident. So the issues that was raised in the case was the four primary issues were there. So first was the plaintiff acting about the defendant's advertisement constitute a binding contract between the parties. Then secondly is the formal notification of acceptance required by the contract in question. So then there is it necessary for Mrs. Carlill to notify the Carbolic company to that she has accepted the offer? And lastly, that is there in evidence that Ms. Carlill gave anything in return for the company's amount of £1,000? So the court's analysis was that defendant Carbolic company argued that their advertisement lacked a binding impact which is necessary to form the valid contract. So they argued that the phrases used in the advertisement did not constitute a legal commitment since the provision of the advertisement were too imprecise to form a contract. So they claimed that there was no time limit to set, and there was no way to monitor how the product also was being used by the customer. So for example, also if a shady customer may not have been used the product and effectively and then accuses the corporation of failing to deposit the money, according to the argument there was no contract since forming a legitimate contract necessitates transmission of acceptance intent. So Miss Carlill didn't openly or implicitly offer the accept the offer in this situation, nor did she do so through any overt behavior. So as a result also, it is evident that the advertisement was merely a marketing technique, and the corporation had no intention of entering into any kind of contract while making an offer to the general public as per the record. So on the other hand, the plaintiff stated the proviso was not vague and that the offer was constituted in such a way that it was evident that if the product was ineffective, the corporation would compensate to a particular sum. To make things easier, also the corporation had also deposited a sum of money in the alliance bank account. As a result, depositing the money demonstrate one-sided intention or unilateral contract that she alleged, and this was a very strong argument which held up in the court. So the plaintiff further established that the money paid to purchase the Carbolic Smokeball company was a consideration. So the advertisement was a not boast in the abstract. In fact, it considered a majority of the key characteristics of the contract, especially a unilateral contract. Then it was also stated that if the specific offer contains some condition and fulfills the requirement, there is no need to accept the offer. acceptance of the condition performed without notification is adequate now. So in this case, it was stated the fulfilling the terms of the condition constitutes acceptance, and the communication of acceptance is unnecessary. Miss Carlill, the plaintiff, got the money at was as that was set in the advertisement, that was £1,000 amount, and she got it. And the law was settled regarding the unilateral contract, and this had a very deep impact into the English law. And also in India, it was a case of Harbhajan Lal versus Harcharan Singh of 1925 case. It was inculcated into India. So according to Allahabad High Court, in that case, this proposition was made for the benefit of the entire world. As a result, anyone can accept this proposal, and the significance of the acceptance is the fulfillment of the proposal requirement. So in this case also, the plaintiff had fulfilled the proposal's criteria by tackling down the youngster and sending the telegram in the Allahabad case. So this does it was also held eligible for the incentive. So thank you. This was all I had to say about this issue. So please remember, this video does not violate any guidelines of Bar Council of India and does not solicit or promote any of the any advertisement, and the sole purpose is educational of this video. And please subscribe to the channel if you haven't already to see more of this content in future. And I'll be coming up with the next video very soon. Thank you.